Honor, this is the second full paragraph from the very end of the opinion where it says, judgment affirmed, all justices occur. Go up 2 paragraphs from there, the second paragraph from there. And it starts with Amy Pitts asserted her marital privilege. Okay. Did not testify at trial, thus rendering her unavailable at trial. The trial court admitted, and this is what I'm referring to, Your Honor, the entire recording. And we find no error under the present circumstances. And this is what I stress. However, we do caution that in certain circumstances, a caller may shift from a non-testimonial statement into a testimonial one. When Amy Pitts explained to the operator that her husband had violated his parole and that he was, quote, wanted, end quote, she came close to providing testimonial evidence.
I would agree.
Because the crime was still ongoing, and I stress this, in her presence, immediate presence, however, the primary purpose remained the prevention of immediate harm to herself, and her statements regarding her husband's parole violation were made to illustrate the prior difficulties that made the current situation such a dangerous one.
All right, says at the bottom, in future cases, trial courts must decide whether a caller's primary purpose is shifted in such a manner as to render portions of the call testimonial in nature. So,
and should, so I didn't mean to interrupt you.
No, and should selectively redact portions of the recording in that case. So I got to decide if I decide that. But at this point, I don't see anything in this transcript which would indicate that it's shifted at this point.
Well, so what is the, first of all, we're not dealing with the Amy Pitts of the world. We're not dealing with the person under the stress of the, I'm not talking about hearsay, of the ongoing emergency. We're dealing with a third-party caller who does not see any of this.
No, but the third-party caller is right next to the person who has apparently some particular person that may or may not have been involved in this particular circumstance, but in their apartment.
No.
And wants the police to come to get them out of that apartment.
No. If they wanted the police to come.
Well, that's argument. That's for us to decide. No. If I decide that, well, then that jury will weight it accordingly.
But no.
Yes.
What happens is...
You may not like it, Mr. Steele, but that's the facts of where we are.
I'm just trying to explain. If the caller's removed, just for a minute, because the caller's not right next to the person in need. The caller doesn't see anything. The person in need, allegedly, that person's not even in the vicinity when the call is made. That person goes back to the supposed emergency.
I have no idea, baby. I promise I can tell you that I don't know. The only thing I know is she came to my house and told me the guy that shot someone named Young Thug or whoever supposed to be shot someone, and that guy is in her house. I don't know y'all can do that. I'm trying to get her out of the house, but she won't answer her phone right now.
The person who the caller is talking about already left the house. That means, if you take that as true, that the caller went back into the house.
But Mr. Steele, you got to look at the totality of the circumstances. Of this particular incident, which I've heard now 3 or 4 folks testify about, and it's not in a vacuum. It's got to be looked at in the totality. You got a car coming into a building, you got a crashing of a gate, you got a shooting, and you got 911 call.
Car coming in building is not mentioned.
But she doesn't know that. But
exactly.
Still, she doesn't know that. But she's at but it's got to put context. Remember, she's at the trail end of somebody that has fled. If the facts, in fact, that's what the court surmises. Now, whether the jury believes that is another thing. But from the facts, it is reasonable to conclude that somebody ran from that particular scene into those apartments and they were shot. That's what's reasonable under the circumstance.
Who was shot?
We don't know.
Exactly.
But that's for them to decide. No. That ain't for me to decide. That's a weight versus admissibility issue.
If we can cross-examine.
Well, no, it's kind of like,
yes.
Ordinarily, yes, but this is one of those circumstances that I'm sorry. I'll make a ruling and we'll see what happens.
Well, I know what will happen if you make a ruling. I'm going to follow your ruling, but
I know that. But it bothers me that you won't be able to do that. But that doesn't make it not inadmissible.
This is an un-American trial to allow in
Why you want to make it un-American? We all follow the rules of evidence, Mr. Steele. Okay, some of them, work out fine. But remember, when you admit evidence, the overarching thing of our rules of evidence is the admissibility of evidence and the highest and best evidence for us to use. Now, depending upon where you fall on the continuum, sometimes that evidence may cut for you and may cut against you. I don't disagree that you don't have a right to confront, but and Crawford and his progeny, guide my direction and my analysis. So that's what I'm going to do. I'm not saying that I don't disagree with you about anything about the fairness or otherwise, but remember, I'm the referee. So
I understand. I'm not questioning the honorable court.
No, I understand. But I want you to understand, I get it, but these are the facts I have. But we may disagree, but
let me talk more about the facts, because I keep feeling like I'm not articulating and I'll just going to piggyback on what this honorable court just said. The overarching purpose of a trial is for the jurors to have the best and highest evidence. The overarching way that we get the best and highest evidence is through the crucible of cross-examination. That is not only statutory, but constitutional. And what we have here is you potentially will find an ongoing emergency. If you find that, and I'm not conceding, I'm going by what you said, how is it, and I'm answering your question, when you said, if I find that it's an ongoing emergency, am I done with the confrontation clause? And I said, Your Honor, no, because the part that you just read, that would have to be redacted. How does that go to an ongoing emergency? By naming Young Thug, how does that go to an ongoing emergency? The caller doesn't know Young Thug. The caller says, the way I listen to it, Young Thug may have been shot or shot someone, however the listener hears that. But she starts with, the question is, so who was shot? I have no idea, baby. I promise you, I can't tell you all that I don't know. The only thing I know is she came running. She came to my house and told me that the guy. Now, why is that?
Because you got a present sense impression, or you have or excited utterance of the person who she runs to the house, and then a woman who is conveying this is in a present sense impression as well. So now, whether or not she told her that or not, that's
important, because
I know it is, but that's for them to decide, because this particular circumstance, it's going to go to weight. It's whatever the jury wants to consider it as. It just is.
Then why don't we just let in all recordings?
Because I can't do that.
Without cross-examination.
Because I can't do that.
You might be doing it here. Judge Glanville, the Honorable Judge Glanville, look at that. Somebody named Young Thug, or whoever that's supposed to be. That doesn't go to weight. That is testimonial. That does not go to the ongoing emergency. The ongoing emergency is
but that's not for the purposes of well, that's one of the things I got to decide. So